Hello, my name is James Dawson. For my case law presentation, I will be discussing the Supreme Court case Andrew F. versus Douglas County School District. This case was argued January 11, 2017 and decided on March 22, 2017. The participants in the case were Andrew F. and his parents and the Douglas County School District. Andrew F. was a student in the Douglas County School District. He suffered from both autism and ADHD. By the time he was in 4th grade, his behavioral problems began to get out of hand. According to an article published in The Atlantic by Laura McKenna, these problems included extreme fears of everyday occurrences, such as going to the bathroom, spills, and flies, as well as disruptive actions that included self-harm, where he would bang his head against the desk and walls, public urination, and nudity. He was routinely removed from the classroom. Andrew's parents did not believe his Individualized Education Program, or IEP, was helping him progress in the school, nor did they believe he was receiving the free, appropriate public education that he had a right to under the Individuals with Disabilities Education Act. In response, they pulled him out of the public school after the 4th grade and enrolled him in the private Firefly Autism House. According to his family, he did much better in private school. However, the cost of such an education was around $70,000 per year. The parents then asked that the Colorado Department of Education cover the cost of his tuition, but the reimbursement was denied. The family then decided to take the matter to court. The question at hand was whether or not Andrew received a free, appropriate public education as designated by the IDEA. The IDEA provides a free, appropriate public education to all individuals with disabilities. However, what does appropriate mean in this sense? Andrew's case went first to an administrative law judge who ruled that Douglas County School District did, in fact, provide him with a free, appropriate public education. The ruling was affirmed by the district court and then affirmed again by the U.S. Court of Appeals for the 10th Circuit. The 10th Circuit based its affirmation on a previous Supreme Court judgment on the Board of Education of Hendrick-Hudson Central School District versus Rowley. The judgment viewed that the requirement of a free, appropriate public education was met so long as the IEP provided for some educational benefit or merely more than de minimis. The case was argued in the Supreme Court on January 11, 2017 and then decided on March 22, 2017. In a unanimous ruling, the court decided to vacate the decision of the U.S. Court of Appeals for the 10th Circuit and remand the case for further proceedings. In his opinion on the case, Justice John G. Roberts, Jr. noted the same Supreme Court ruling mentioned by the Circuit Court Judge, Board of Education of Hendrick-Hudson Central School District versus Rowley. Justice John G. Roberts, Jr. noted that the previous case ruled that an IEP for a student in a general classroom should enable the child to achieve passing marks and advance from grade to grade. While the circumstances for a child outside of a regular classroom may differ, he did agree that requiring passing marks from grade to grade go beyond what the Circuit Court termed as merely more than de minimis. Furthermore, students outside of the classroom should at the very least have the chance to meet challenging objectives based on their circumstances. In schools where the de minimis is seen as the standard for free, appropriate public education under the IDEA, this case could set a precedent that improves the education provided to individuals with disabilities. Or, at the very least, it will give them some legal standing when they are not provided a proper education.